So in law school, they'll tell you property is a bundle of sticks, right? It's not one thing or another. It's like a bundle of rights. And the question when you transfer property is, which of those sticks that I have I then given to you? Okay, so normally if I sell you something, I might give you all the sticks, and you get the Harry Potter book, and, well, let's not use a book. That's wrong. You get what's something that is totally up to you. Let's say it's your, I don't know, car or something like that. You get the car, and if you want to beat it up with a sledgehammer or take it apart into parts or paint it purple, you can do whatever the hell you want with it. And I, as the seller, I don't have anything to say about it. When I sell you a book or software, copyright law says if I'm the owner, I retain some of the rights. Okay, so maybe like CompUSA doesn't, but the copyright owner holds on to some of the sticks. CompUSA gives you all the sticks, and you can do anything you want that doesn't violate copyright. Well, licensing versus sale encompasses these same kinds of issues, except instead of the sticks that are retained being defined by the law and limited defined by copyright law and limited by fair use, what sticks are retained is defined in the licensing agreement and could be more or less than what copyright law generally would allow. And depending on whether the court enforces that license, there might not be any kind of sticks that are retained by the public or given away regardless of what the seller wants. So I might say, you know, in my license, no fair use or no reviewing or no benchmarking or something like that. And if those licenses are enforceable, then I get to hold on to those things. I can say, you know, you can only use it for these purposes. So it's really, you know, there's kind of a broader battle going on about the difference between owning something and being free to do with it what you want, what Professor Ed Felden calls the freedom to tinker, you know, or, you know, if you read Make Magazine, kind of the Maker Manifesto. I want to open the box and be able to see what's in there and tear it out and mod it and do whatever I want with it because it's mine, and that's what freedom means, that's what property means. Or this kind of license world where everything is transferred but with conditions that control you and control what you do to make sure that you're never using any kind of software or property in a way that, you know, makes the owner mad. And legally, there was a real push in about I would say maybe the early 2000, like late 90s, early 2000, to try to change contract law to make these licenses and the way that software is sold really like very legally approved and enforceable. And so some states passed a version of this set of rules about commercial software license sales called UCITA. And then after a couple states passed it, there was this huge like uproar, and people were totally against UCITA because they saw that basically what it was going to do could be to supplant copyright law, which is supposed to be this balance between fair use and incentives, and just have it be whatever the seller tells you is what you have to do, and you're subject to that whim, and there's nothing you can do about it. And so the UCITA movement kind of got squished down, and we haven't really gone and answered the question fully about what exactly all these licenses mean. So my Wired column last Wednesday was about EULAs in terms of service, and you can read it. There's some interesting cases in the area now, but you know, we've seen, just to kind of generalize, we've seen cases that have said, hey, there's a license, you bought it, you kept using the product, you obey the license, that's what a contract is. Then there's cases that say, you know, let's be real, people don't really have a choice when they buy something with a license. It's a take it or leave it sort of thing. You don't get to call up Microsoft and say, you know, on page 340 of your EULA, I really don't like the term that says that I'm not allowed to, you know, use the product in this particular way. Can we talk? I'll pay you an extra $2 if you know, take that term out of the EULA. So because it's just this take it or leave it kind of thing, there's something that changes the balance of power between the seller and the customer. And so we're going to look at the terms of the license with a little more suspicion. And if we find the terms are oppressive or bad in some way, then maybe we're not going to enforce them. And we've seen a couple cases like that, particularly with refusing to enforce arbitration provisions. Because a lot of states don't like these arbitration provisions. They enforce these, you know, kind of very pro-consumer rules, and then these arbitration provisions say, oh, even though you live in California and you've got this nice consumer protection law, you promised to do arbitration. And the California courts are like, no, I don't think so. Our legislature has decided that this is what we want our customers to have. So we're not going to enforce these EULAs, all the way to some enforcement by the New York Attorney General's office, who has sued a couple of companies that have particularly anti-free speech provisions in their EULAs, where they say, you're not going to criticize this product without written permission from us. And the Attorney General's office has sued some of these companies, and they've never, I don't think they've had courts rule on it, but in every case the companies settled and said, okay, we're not going to put that in our license anymore. So you can see that the effect of a license is quite a bit different from the effect of like, oh, I'm just selling it to you and it's a car, or even I'm selling it to you and it's the Harry Potter book and you're not supposed to take photos of it and then put it up on the internet. But if you want to rip it up or resell it or make it into like a coaster or, you know, whatever you want, wear it as a hat, you can do whatever the hell you want with it. So there's a very, very big issue. Okay, where am I going? Okay, so in Michael Lynn's case, just to sort of close this part of it out, I think this is sort of classic fair use. What do you need to do when you're doing reverse engineering to ensure that you're going to fall into the classic fair use thing, like I think Michael Lynn did, although of course he did still get sued, but it worked out, you know, pretty well in the end. Legitimately obtain the program. Don't infringe in the final product. Make sure that you're making the copies because you're trying to understand the product that you're working on, that you're reverse engineering. And don't steal the software you got to reverse engineer. Okay, so that's sort of important. Not super interesting intellectually as a legal matter, but really important and an important thing to defend because of the obvious impact it has on computer security. Okay, so we talked a little bit. Yeah. Okay, so his question, he's saying, well, in some of the exceptions, he's talking about an exception for encryption and an exception for security. And I want to make really clear, and I think what you're talking about is the DMCA anti-circumvention provisions. I am not talking about the anti-circumvention provisions here, okay? What I'm talking about is regular old copyright law. I'm the owner. I own the copyright. I sell it to you. There's rights I retain. There's stuff you can do. What you can do is reverse engineer. Reverse engineering is fair use, but there are cases that say you don't get to avail yourself of that defense if you do. Where am I? Yeah, if you do these things. These things will impair your ability to raise the fair use defense. Okay, the DMCA is another statutory scheme. People have called it para-copyright. It doesn't actually have very much to do with copyright, the way that we've implemented it here in the United States. So I'm going to talk, I wasn't going to talk that much about the DMCA because it's really complicated, but basically, let me see, I know I have a slide on it, so let me just go to there so you can kind of see it. Here we go. Okay. So basically, the anti-circumvention provisions are a different part of copyright law. It's under the Digital Millennium Copyright Act, but it doesn't have anything to do with copying, right? This is a statute that prohibits basically cracking a technological protection measure, which you can think of as DRM, that controls access to a copyrighted work. It also prohibits trafficking in a tool or service that helps others to crack or circumvent a TPM. Okay? Notice that it doesn't say to copy the copyrighted work or to do any of the things that the copyright owner is entitled to do and you're not allowed to do. It's just to access the copyrighted work. Okay? So, for example, you know, if the copyright owner doesn't give you authority to do, if you don't have authority to do something, and it gives you, but you're still getting access, it's sort of wrong. So take a look at if you're familiar with the DCSS case. This is a case about DVDs, right? And people have the right to, there's nothing in copyright law that stops you from playing your DVD that you've legitimately purchased on any DVD player or on your computer or anything like that. That's all sort of okay under copyright law, you're not making a copy. You're not doing anything that infringes the exclusive rights of the copyright owner. But because they put controls on how you access that work, i.e. they region code, you can only play these DVDs bought in this country on these players, and they don't allow or license the decryption technology to players that also are copiers. They didn't used to, like your computer, or they want you to not be able to skip past the commercials or that sort of thing. These are controlling access to the information on the DVD, and the DMCA kicks in. Okay, so it's not really copyright. This law has a couple of exceptions for reverse engineering, encryption, and security research, and those exemptions have very specific elements that you have to meet in order to get to those, in order to have those defenses apply to you. But that is different from what I'm talking about here. So this is important. It's important to security research. I've talked about it before, but it didn't come up in either of these two cases, and it's complicated, so I'm not going to talk about it more today. But you'll see, for obvious reasons, the same kind of factors that courts and Congress think are relevant in this one area to when you're a good guy and when you're a bad guy are the same, also carried over in fair use. Are you a good guy or are you a bad guy? And if you stole the code in the beginning, they don't like that. That makes you more of a bad guy, right? Whereas we all know sometimes there's reasons why you have to get something kind of nefariously, like the company has a policy that they don't sell anything to anybody who is trying to take a critical look at it. They only want yes men to have a copy of their thing, right? Okay. So maybe stealing is too harsh. So as we've discussed kind of through these examples, reverse engineering is generally legal. It's generally thought of as a defense as opposed to a right. And it has some limits by contract law and by the DMCA anti-circumvention provisions. And we've seen how the licensing can kind of come in, because if I say, well, you're not allowed to purchase this or something like that, you can be you can be limited in what you're allowed to do with the thing afterwards. So how robust, really, in a world where there is so much licensing, as the question indicated, how robust is reverse engineering, and how legally protected is it, given that there's all these other kinds of doctrines that sort of come in and infringe upon it and can control what it is that you do. Okay. We talked about the DMCA. Oh, let me just mention one thing here. So one thing about the DMCA I just want to point out is that it's been successfully used to threaten researchers in the past, and I can go through the list. Ed Felton's team, when they were looking at SDMI, the Snowsoft guys, when they were looking at HP. There's a ton of examples of how it's been successfully used to threaten researchers in the past. But we've never gone all the way to where there's a court case and people who are doing research were actually sort of been upheld in that way. And we're also seeing a little bit of cracking in the DMCA hegemony, the power that this statute has had, in a couple of ways. One is that there are some knowledgeable members of Congress who want to change the DMCA. They're beginning to realize how broad the reach is and thinking well, maybe we went a little too far in the way we phrased it. Our goal was to protect, the Disneys of the world and encourage them to put their stuff out on, the network in digital format. But what's ended up happening is that we're seeing printer companies using it to go after aftermarket printer cartridge vendors. We're seeing garage door companies using it to go after the aftermarket garage door click